welcome to the second video about General Data Protection Regulation. By the end of this video, you will know when you are allowed to process data. I'm going to talk about the following topics. When is it legal to process data? What does giving consent mean? When are you allowed to process data? And does GDPR affect companies of all sizes? So, when is it legal to process data? Article 6 of the GDPR lists the instances in which it is legal to process personal data. Don't even think about touching somebody's personal data. Don't collect it, don't store it, don't sell it to advertisers, unless you can justify it with one of the following. The data subject gave you specific, unambiguous consent to process the data. For example, they've opted into your marketing email list. Processing is necessary to execute or to prepare to enter into a contract to which the data subject is a party. For example, you need to do a background check before leasing property to a prospective tenant. You need to process it to comply with a legal obligation of yours. For example, you receive an order from the court in your jurisdiction. You need to process the data to save somebody's life. Well, you'll probably know when this one applies. Processing is necessary to perform a task in the public interest or to carry out some official function. For example, you're a private garbage collection company. And it is legal if you have a legitimate interest to process someone's personal data. Now let's see what giving consent means. There are strict new rules about what constitutes consent from a data subject to process their information. Consent must be freely given, specific, informed, and unambiguous. Request for consent must be clearly distinguishable from the other matters and presented in clear and plain language. Data subjects can withdraw previously given consent whenever they want, and you have to honor their decision. You can't just simply change the legal basis of the processing to one of the other justifications. You need to keep documentary evidence of consent. Do you need a data protection officer when processing data? Contrary to popular belief, not every data controller or processor needs to appoint a data protection officer, DPO. There are 3 conditions under which you are required to appoint a DPO. You are a public authority other than a court acting in a judicial capacity. Your core activities require you to monitor people systematically and regularly on a large scale, for example, your Google. Or your core activities are large-scale processing of special categories of data listed under the Article 9 of the GDPR, or data relating to criminal convictions and offences mentioned in Article 10. For example, you are a medical office. Does GDPR affect companies of all sizes? The answer is yes. Let's talk now about GDPR and companies. The application of the data protection regulation depends not on the size of your company or organization, but on the nature of your activities. Activities that present high risks for the individual's rights and freedoms, whether they're carried out by an SME or by a large corporation, trigger the application of more stringent rules. However, some of the obligations of the GDPR may not apply to all small and medium medium-sized companies. For example, companies with fewer than 250 employees don't need to keep records of their processing activities unless they conduct processing of personal data, and this is a regular activity. If the processing of data poses a threat to individuals' rights and freedoms, or if it concerns sensitive data or criminal records. Similarly, small and medium enterprises will only have to appoint a data protection officer if processing is their main business and it poses specific threats to the individual's rights and freedoms, such as monitoring of individuals or processing of sensitive data or criminal records, in particular because it's done on a large scale. When the GDPR came into effect, there was a misconception that it only applied to multinationals and that small business owners didn't need to bother with it. The truth is that the regulation applies to all organizations that process EU residents' personal data, whether they are sole traders, small businesses, or conglomerates. Even a company with only one employee has to comply with GDPR, as it is managing employees' personal data. Thank you for your attention.